Hi, my name is Stephen Sanders. I'm an attorney at the Green Law Group. We are primarily a construction and real estate firm. We also handle employment matters, and our client base is predominantly contractors. I'm going to present a seminar today on dealing with contracts from a contractor's standpoint. The types and forms that are published in the industry that are commonly available, the AIA, ConsensusDocs, and as promulgated, those additional documents as promulgated by AGC. AIA being the, I'm going to probably butcher this, but the American Institute of Architects, and Associated General Contractors. ConsensusDocs is a group of trade associations, and the AGC partnered up in the beginning with AIA to produce documents that are considered maybe more equitable, a little more fair amongst all the parties, maybe not as weighted as the AGC and AIA documents have been accused of being. AIA dropped out of that ConsensusDocs group in circa 2017 and promulgated their own updated AIA contract. So I'm going to get into some of the idiosyncrasies of these forms as I deal with them on a daily basis. And then also I'll discuss here and there what I call Frankenstein forms. I don't think I'm the only one. They're usually pieced together forms from various published forms and maybe the lawyer's own creativity, or maybe their theft of other lawyers. There's a lot of different forms of contract for construction projects floating around out there. So generally, when I'm referring to something that isn't a published form, I'm going to mention, I'm going to call them Frankenstein forms. Another set of forms I'm going to mention that isn't, I'm not going to have a slide on it, but here in Southern California, we have a great resource. It's the Builders Bookstore, and they have a form which is really more geared towards small projects. I mean, you would not want to use those forms for projects, you know, in the six figures. You need something a little more, in terms of gross construction value. You want something, a form that's more robust to deal with conflicts where you have significant potential damages. So, but that Builders Bookstore form is great for the smaller projects. I'm not going to address that here. It's pretty straightforward, simple type of form. The only thing that I will mention is that it doesn't contain a prevailing party attorney's fees provision. So I typically include an addendum with that form so that the party who would prevail in any dispute would get attorney's fees. I'm going to discuss that issue more as we go through the various published forms. And typically, the kind of general principles that I'm going to apply would apply cross-platform in any context. I'm going to kind of cover the things that are most fundamentally important in the contract negotiation, kind of what we like to refer to as deal breakers. So let's see what we got. Here's our sponsors for this today. Ventura County Contractors Association Builders Book, heretofore mentioned. Also Ventura County Credit Union, and you know, great place for your loan needs. And the Blue Book, Billy Gribble, and is our local rep, and you know, great place to get leads for contractors, as I'm sure most of you already know. So, you know, I'm a lawyer, don't hold it against me. And I give legal advice for a living, but I'm typically paid to do that. And I would only give legal advice where I had a representation agreement. The things that I'm telling you are general information. If each issue that you're going to deal with is always fact specific. Every negotiation, every dispute, they all have their own fact specific characteristics. So I would encourage you to consult with a competent and retain a competent construction lawyer if you are going to be negotiating 6-figure, 7-figure, 8-figure contracts. That is the domain of lawyers who are experienced in construction law, and there are many of them in our community, maybe not enough, who are experienced in drafting construction law contracts. So, as I indicated before, we're kind of a full service shop for contractors in their human resources, employment needs, as well as their payment collection, mechanics liens, and foreclosures. And we also do insurance coverage disputes. We've got a really strong lawyer here, Jeff Coiner, who handles our insurance matters. Matthew Bechtel handles our employment matters, so they're a good resource. Feel free to call us if you've got any issues. Here are the folks that I'm referring to. I'll just mention too that Mike Clopor runs our estate and trust program here. So if you have estate and trust needs and you're getting to be of a certain age like me, then you should be thinking about getting that kind of work done too. So the 3 document published sources we're going to be addressing today are AGC, ConsensusDocs, and AIA. We're going to be using the AIA forms and then the AGC sample forms of the ConsensusDocs. They basically published them with their own watermark. Generally speaking, the A100 series of the AIA contract forms are either the long form or short form type contracts. The long forms incorporate the A201 general conditions. You want to make sure there's a lot of important information in the A201. To be quite frank, I think the A201, in terms of your editing and modifications, is more important really than either the A102, which is a cost of work plus fee with a guaranteed maximum price, and the A103, which is the long form without a guaranteed maximum price. Those forms are important, and we certainly do make edits on those forms, but the A201 is critical. It's about 45 pages long, and depending on how the contract is being administered, whether it's owner administered on behalf of the owner or through an owner's representative, or whether it's the architect of record. The AIA has been accused of being too architect-centric. And there's a place for that in 7- and 8-figure contracts, probably more 8-figure contracts, where the architect really is running the show on behalf of the ownership group or the developer. And so in order to use the AIA in a more in smaller projects, really anything under 10 million, you need to decide whether it's economically feasible to have the level of architect involvement that's contemplated in the AIA original form documents. That is a lot. I mean, there's a significant expense to an owner in that, and many of them don't want that. They typically have a bank loan. There's probably a draw inspector that will be reviewing draws for the bank. They'll typically hire their own owner's rep, some kind of construction consultant. And so, they'll want to refer to the architect only as a matter of interpreting the plans that the architect has drawn, and maybe making sure that there's not inconsistencies with the engineering and other design professional details. So, if the architect's not going to be paid to administer the project, and the drives are going to be administered in another way by the owner, then much of what is in the A201, significant portions of it needs to be edited. And I would strongly encourage you to have a lawyer do that, at least you know, in the initial few times that you're going to have that kind of project. Certain things have to be rewritten. I would also point out that the AIA long forms tend to designate the architect as the quote unquote initial decision maker. I primarily represent contractors. I do represent architects, and you know, I have the occasional architect client, but predominantly I'm representing contractors. And so you know, it's not in my, I don't believe in having the architect be the initial decision maker in any dispute with the owner. They are not independent, okay? They're hired by the owner. So typically where we're going to do it, keep the initial decision maker provision in the A100 series and A200 series forms, you know, where I don't strike it out altogether as part of the alternative dispute resolution parts. I'm gonna have the parties agree to some neutral third party, maybe a local construction lawyer or somebody who can come in, listen to what the parties have to say, and maybe it's somebody that would be trusted and knowledgeable. And then if the parties don't agree on the initial decision maker's decision, then it gets referred to mediation and arbitration. You know, the bottom line with these contracts, any contract form, you know, there are three fundamental things that I think all of these contracts, or in most instances, I shouldn't use the term all, but in most instances, there are three things that I'm going to want to see for a contractor. I'm going to want to see a right to suspend work or terminate for non-payment, where the owner does not follow the terms of the contract. And if it's a general contractor, or if a subcontractor is not getting paid for one reason or another, and one party or the other is, you know, that isn't the unpaid party is not following the terms of the contract to handle the dispute, I want my, you know, contractor to be able to give a written notice and provide us a written stop work notice, either by statute or the terms of the contract. And I want, and preferably by the terms of the contract. And I want to make sure that they are able to suspend their work. Nobody, you know, should be working for free, and nobody should be working as a slave. And fair forms of contract give stop work notice provisions and remedies. I am also a big and firm believer in arbitration clauses. You know, I know the two competing theories or schools of thought are, well, arbitration's expensive because you have to pay a private arbitrator. You know, maybe there aren't the kinds of discovery protocols and things that you might want to get. You know, particularly where a certain party in the arbitration is controlling key information and is not providing it, you know, so you have more limited discovery typically, or at least you can anticipate that. One way around that is to include statutory discovery, particularly in big contracts, referencing the Code of Civil Procedure. There are other ways to deal with that too, and there are different types of arbitration. There's local arbitration, and then there's the federal rules, and depending on the type of project, if it's you know, in scale, there are pros and cons to each of those. I won't get into that in great detail here. I don't have a lot of time for that. But these are the kinds of considerations that an experienced construction lawyer is going to want to assist their clients with in figuring out what the type of proceeding should be. But frankly, the pros of doing arbitration are you have an experienced, typically a retired judge with construction arbitration experience, and or you have an experienced construction lawyer managing that arbitration, acting as, or maybe a panel. But they all have, you can select them, and you can select them based on criteria that will be advantageous to the ultimate outcome for both parties, because you have someone with knowledge of construction matters. You know, when you're litigating in superior court, you know, most of those judges have, you know, 400 open files. They don't have the time or the attention, even if they have the knowledge, to be able to address the parties' issues thoughtfully. You know, you do put up with, you know, an arbitrator sitting in equity, and the accusation is they're often, you know, splitting the baby. But if it were me, if it's a big project and somebody is not willing to engage in arbitration, I am, you know, I'm highly suspicious. Would I consider that a deal breaker, like I would a withholding a right to suspend or terminate a contract for non-payment? I don't know if it's a deal breaker, but it's close. And then finally, and what I would consider to be the single biggest and most important deal breaker, and it's not just because I'm an attorney, it's that any contract for construction matters in California, as far as I'm concerned, should have a prevailing party's attorney's fees provision, except in very rare situations, when you're dealing with very, very you know, wealthy parties that you represent as an attorney. You know, they're always going to be trying to make sure that there isn't a fees provision. But for, you know, a guy who works for a living, a contractor, you should make sure that your agreements have prevailing party attorney's fees provisions. And don't get confused, because there's attorney's fees provisions all over a contract, particularly for a subcontractor in the indemnity basis for recovery, but that is a unilateral, one-sided, you know, recovery. You want the ability that if there's a dispute over the contract provisions and any of the work therein, you want to be able to recover your attorney's fees based on a prevailing party theory. So, and if it's not in a contract, you may not in fact have it. It's not expressly in a contract or otherwise in the statute, and you can't rely on the statutes. This is a typical A102 2017 form. This is just the first page by way of example. This is a cost of work plus fee with a guaranteed maximum price. The A103 version of this has no guaranteed maximum price, but it's cost of work. What do I mean by cost of work plus fee? You provide a draw, you know, on a periodic basis. Maybe it's monthly, maybe it's bi-monthly, and you provide your documentation as to the cost. You lay it out for the owner. Maybe some portions of the contract would be lump sum. I would encourage contractors who are going to self-perform work that they do that on a lump sum basis, even if it's in the context of a cost of work, that they negotiate that portion of the agreement on a lump sum basis. It's cleaner, it's less complicated in how you would document your own labor. But you know, we can discuss that if you you know, making that decision and you call me in my office. The fee is typically your overhead and your administrative overhead and your profit. One of the things I tend to do in most of these agreements, you know, we live in an age where a lot of what used to happen on site in the job trailer is now happening at the office. I strike language now that says that the overhead is limited to things off-site, and that your Division 1 general conditions are limited to things on-site. I tend to want my contractors to be specific what's included in Division 1 and be specific about any labor costs that they're going to incur off-site. And typically I have them add a rate sheet in all circumstances, so that later on during the course of the project where labor rates are at issue, I have them include their burden, so it's a disclosed burden, and the owner gets to sign off on it. These are very important later on if you get into a dispute over a cost of work plus fee contract. understand that the any contract with a guaranteed maximum price and a cost plus fee arrangement like the AIA A102 or the ConsensusDocs, I think it's 230 forms, they're commercial forms of contract. They are often, however, used in big luxury home builds I'm seeing for residential projects. And as it stands right now, what we're doing is if it's a developer, we'll do a waiver of the home improvement laws properly crafted, which may or may not be effective. That would be up to a finder of fact later if there was a dispute. But we do a waiver of the residential provisions for a developer, someone who's a professional real estate developer or entity. And then we also do otherwise we do an addendum to kick the bases, so to speak, of the Home Business and Professions Code section 7159 contract requirements. And it's about a 6 or 7 page addendum with all of the various home improvement statute requirements. Because it's a cost plus fee with a guaranteed maximum price type form, you have disclosed costs up to a guaranteed maximum price. And then after that, the risk is on the contractor. One of the things that happens is particularly unscrupulous developers would like to place the risk of the loss of savings, okay, onto the contractor. Meaning, you want to make sure that if you're signing a cost plus fee contract with a guaranteed maximum price, that you as the contractor get the control of those savings, and the ability to reallocate them at your sole election. Okay, you will need to document that as part of the cost plus documentation process with change orders or with budget reallocation forms. Something you have to give the owner notice of the reallocation and the reduction of the cost line item, typically by CSI division. You're using the master format codes, you should be. And then you track all of that back to your budget. The other thing that this impacts is your contingency and the savings. If they're absolutely, the developer is absolutely requiring a savings to the owner or some kind of split, then the contractor needs to negotiate a bigger contingency. Okay, and it needs to be very robust. Underneath that guaranteed maximum price. So, in terms of dealing with this, negotiating with this, I strongly encourage you to have counsel and not fly solo on a complex guaranteed maximum price type contract, because that's potentially bankrupting liability. And there's so many things. I mean, it's a construction project. Of course, things are going to go wrong. It's just how bad will it be? Okay. And to what degree of risk is the contractor willing to take? And why should they, given that it's really the developer's risk, because they get the benefit of all of the sale rewards if they win. So, we can, certainly discuss the form and format of dealing with those issues if you call. This is I believe a short form AIA, it could be long form, but I think it's short form. AIA 401. This is an older version of it that I'm just using by example. If you're using an AIA document, you need to use the subcontract with AIA, or you need to spend a lot of time redrafting your own Frankenstein subcontract if you're a contractor, so that it's consistent with what the AIA requirements are. I mean, let's face it, okay, contracts are a risk shifting instrument. Their whole function is to shift risk. And so ultimately, if the general contractor is taking on significant risks in the prime contract, they want to pass those risks on through to the subcontractor. Negotiating for a subcontractor, I need to make sure that a larger proportion than what is a fair risk should not be passed on to the subcontractor, and make sure that what the market will bear, so to speak, in terms of risk for a subcontractor is met. Certainly prevailing party attorney's fees provision and a right to stop work in the event you're not getting paid per your subcontract and suspend your work. Those are two absolutely critical issues. The other thing that needs to happen in this wildly, fluctuating market for materials costs is there needs to be an escalation clause where there's significant material commitments. We've seen all kinds of problems related to lumber tripling, steel, aluminum products, rising and falling. And then so subcontractors and even general contractors with committed bids need to be very careful to have escalating clauses in both their prime and particularly in their subcontracts. What risks someone will bear is not a legal decision. Okay, I'm your lawyer. It's my job to tell you what legal risks there are, not the business risks necessarily. Contractors are almost always. I mean, I'm a contractor, but on paper, but not in reality anymore. I couldn't be trusted to build anything. I wouldn't build, my own shed. So, at this point in my career, but I will counsel my clients in terms of what the legal risks are that they're taking in signing contracts, taking certain actions. But I will tell you that you need to, as a subcontractor or as a general contractor, you need to make sure that you are managing the risks that are appropriate to your own success and your own financial capabilities. You should not reach too far and too high because the fall can be tremendous on projects that you're not prepared to really step into. Insurance is a risk shifting platform. So are bonds. Certainly in public works, all my public works contractors deal with bonds regularly. We're seeing them in private, large private projects too. We're starting to see them in very expensive multi-million-dollar residential projects, particularly new build, where there's, $20, $25 million homes. If there's a bonding requirement, you should probably discuss that. If you're not familiar with bonding, you should retain counsel, and we should assist you in that process, at least making sure that the appropriate coverages are being had. And we make referrals to insurance and bonding agents, a variety of different insurance agents, depending on the circumstances. So I'm going to focus primarily on insurance. One of the major pass-through requirements into a subcontract is the AIA A101 insurance form should be provided to the subcontractors, and there should be someone in the prime contractor's office that's making sure that all those requirements are being met on the part of the subcontracts. There needs to be follow-up on getting all the additional insured endorsements. You should be aware that there are policies out there running around that require where there are a breach of the policy on the part of the contractor and not seeking, particularly on a general contractor, not seeking to get the additional insured endorsements along with the certificates of liability from all their subcontractors. I tell my contractor clients, hey, I'm not an insurance broker, and even though we do handle insurance matters here, more on a function of coverage and dispute, I send my contractor clients to their broker in order to make sure that they meet the qualifications and the policy of the AIA 101, either if they're the prime or the subcontractor. So the other thing is, you know, when I'm dealing with a prime contractor, I want to make sure that I have the right framework for insurance on a project. You know, it can be cheaper to get umbrella, which is a secondary coverage, rather than, you know, if you need to get $10 million of coverage, you know, will the owner accept a $2 million aggregate policy and then a $10 million umbrella instead? Because I may, you know, that may be cheaper. And so, and those are issues that you'll address with your broker, but should be part of your negotiating process before you sign a contract. And, you know, I tell my contractors, you know, not to sign offers until you have, you know, tacit agreement, and don't send your signature out if somebody else hasn't already signed the document, because you don't know whether you're in a position of a final decision yet or not. You want to make sure that you have a pretty good idea, but then you also need to make sure that you always get a copy of a fully executed contract. Do not do any work if you don't have a fully executed contract, period. If it's stale in getting that fully executed contract and it's been going on for a few weeks, you need to consider maybe suspending performance and canceling your signature on that document. You know, if you have not gotten a signature until they demonstrate that they've signed your contract. I know that there are a lot of general contractors out there that are somewhat unscrupulous that will want to send unsigned contracts to their subcontractors, and that gets everybody in trouble. It's not a good idea. Insurance companies may take advantage of it. The owner may take advantage of it. It's just a mistake, okay? And, you know, you negotiate in good faith, you sign contracts. Now, back to the issue of insurance. You may have a project that would be better served by a contractor-controlled insurance program or an owner-controlled insurance program. You know, particularly, I like them, you know, where I'm trying to avoid some of the standard coverage exemptions, subsidence, things like that. I want one, you know, policy, one big, robust insurer covering all of the expense of it, and then they can go find the appropriate defense counsel for the various parties to sort it all out. There are situations where even on a residential project, I'm going to make a recommendation to a client to do an OSIP or a CSIP, and I would encourage you to consider that. In terms of your payment applications, the AGC provides an excellent framework with what I'm going to call the G702 and the G703 documents. The application and certificate for payment is the G702, and then the G703 is the continuation sheet, which shows the schedule of values, typically based on a division, the CSI divisions from master format. At least I would encourage you to do that. The G702 and 703 are the standard forms. They're called out for, I believe, in the 2017 series as part of the payment draws. I've also seen them incorporated into ConsensusDocs forms and Frankenstein forms. You know, the G702 and the G703 are a couple of considerations there. On the 702, if there's no architect administration of the draws and the contract, then you need to get an express waiver from the owner on any requirements for notary or certification. unless there's a bank involved and the bank inspector is requiring it or something. It's impractical. It slows everything down. And ultimately, if I'm a contractor, I don't want to mess with that. So I'm typically seeking, I'm already on the hook anyway. It's a draw, okay. Getting this signature notarized. You've seen my contractor signature on a contract. Why do you need it here? Okay, this doesn't make a lot of sense. I understand it in the context of protecting an architect who's administering a draw, who's feeling like they're between a rock and a hard place between the owner and the contractor, maybe. I think I'm not saying that provision doesn't have merit. And it certainly has merit if a bank inspector wants it, but beyond that, I wouldn't say. Particularly on small projects, time is critical. You need to do what you can to reduce your administrative costs wherever you can find it and still perform, beyond the standard of care. I also tell my contractors that the G703 continuation sheet is not enough. You need to maintain a master schedule of values, which shows all of your change orders and all of your applications to billing, and also indicates how you came to your percentage conclusions. You, particularly on a cost plus contract where you have full disclosure on all that stuff, the excellent contractors that I deal with, the ones who are excellent, typically include a master schedule of values that shows the information and documentation behind the 702 and 703 in a big spreadsheet format, or there may be other formats out there not available, that I'm not aware of. It will show your budget reallocations. It'll show the change orders. It may show pending item. Other than that, my general advice is if somebody's not following the terms of the contract in terms of notice, and you're getting behind 30 to 45 days on a draw, you should be talking to me or one of the lawyers at this law firm or another competent construction lawyer. There are lots of things that can go wrong. There are lots of triggers and things like that for a contractor to secure their right to payment. They are running a maze and they need the assistance typically where you're not getting paid of a competent construction lawyer. I covered some of this stuff before. The consensus docs tends to be less architect-centered. The architect has less involvement. In fact, normally where the architect is administering the project, I have to add in certain provisions from the AIA to make that more functional. Typically the consensus docs, and I guess I would characterize it as pushing off the owner's involvement with the architect on the design agreement between the owner and the architect. And so that it's governed by that. The contractor just needs to deliver it up to the owner. The owner can do what he wants to do with his architect in terms of the draw administration. Now, obviously, RFIs go to the architect and other things like that. I think the consensus docs tend to be more common sense in dispute resolution. They give a fairly balanced and robust notice requirements on both the owner and the contractor. And those are common sense notice requirements to avoid conflict before it gets out of hand. But I would still say that generally speaking, the consensus docs and the AIA forms are more fair all the way around than most of the developer prime contracts and general contractor subcontracts that I see that I characterize as Frankenstein, cobbled together or from other sources. It's disappointing that the AIA didn't continue to participate in the consensus docs and went back to their own forms. I have some criticisms of those forms, in particular that they tend to drive, from a financial perspective, they make using other AIA forms essentially a substantial part of that agreement, where you have to buy these other form packages potentially in order to utilize the AIA form. And it's now arguably in the 2017 a basis for breach. Now, whether it's a material breach or not, you know, but who wants to be arguing over that? Okay, so I tend to strike a lot of those requirements out, you know, when I'm going through the A100 and A200 series. Let's see. This is the opening to the consensus form. I believe this was an A235 long form. It's promulgated by the AGC. They also have a short form agreement. You know, when do you use a short form, when do you use a long form? Okay. I would only use the short forms typically if I'm dealing with a relatively small project, probably under 100,000 gross. Okay, maybe 200, depending on the circumstances. I don't like them. I add things to the short forms, both the AIA and the consensus forms. You know, I'm not terribly impressed with them. I understand why they are what they are. And sometimes, particularly in residential projects, owners get spooked. You know, I'll use them maybe in TI work, and I'll make additions to them in TI work, tenant improvement work, you know, that sort of thing. We use them, but for most big development, you know, type projects, or, you know, new build construction, or even multi-million-dollar residential remodel, where the home improvement law, you know, type contracts are used and required. You know, I might use a short form, but most of the time I'm going to use the long forms. This is the AGC version of the cost plus fee with the guaranteed maximum price and change orders. You know, the AGC promulgates a change order form. The AIA promulgates a change order form. So, you know, what do I want in a change order form? Time and money every time. Okay, every change is going to have a time element. Every time a change is going to have a money element. And then you should always include your general conditions costs, whatever the time impacts as a cost are associated with whatever that change is. You should include it in the change order. So those are three components: two cost items, the actual cost of the work, and the Division 1 extension for costs, and time. Okay, either it's the time necessary to get through the administrative process of developing the change order, you know, et cetera. Now, sometimes, you know, owners will say, well, that's not on the critical path, and it's like, well, you know, I appreciate that, but you know, the one day it took for my staff to draft this and do this work and put together the corrective work and do the estimating and all that is one day they're not working on something else on your project. And maybe it's two, maybe it's three, maybe you're waiting for an approval on an RFI for a period of time, even ahead of that, or supplemental information from the owner. So you're like, okay, so I believe every change order has a time element, and I believe every change order should have a cost element, unless it's a zero cost change order. There are situations where you're just substituting like kind. So, but even that has time. So there you go. So I've got a couple other standard subcontracts in here. There's short form and long form subcontracts. If you're a general contractor, I strongly encourage you, if you're using the same set of subs over and over again, consider doing a master form of subcontract that you renew each year with those subcontractors, because they're working on multiple projects, and then just do a project specific addendum. You can call us to address that. If you're commonly using AIA, we'll adopt the AIA provisions. If you're commonly using ConsensusDocs, we'll adopt the ConsensusDocs. If you're using a Frankenstein form, get ready to pay us for a couple hours of attorney time to unwind whatever it is you're doing. Purchase order. You'll never use a purchase order unless you're out of your mind, except in a commercial context. You would not use a purchase order in a residential, ever. Purchase orders are a commercial form of contracting, and they have special rules. You know, they should really only be applied in a materials or equipment context. They really shouldn't be there should not be used where there's labor for installation, okay, or where the equipment provider is providing an operator, okay. If there's a labor component, you need to use that, period. If you are using purchase orders, you know, there are, you know, provisions that you'll want to add to those specific to the type of work that you're doing and the type of materials or equipment that are being ordered, and particularly, you know, in equipment contracts. So, or anything where there might be hazardous, you know, or union issues. There's all kinds of things that come up in these. So, you know, reviewing your purchase order functions, you know, would be probably a good idea on a regular basis, and having an attorney consult on that would be good too. Okay, and again, this is, you know, a confirmation of offer form is something that you use in the context of purchase orders and commercial transactions, where, you know, you need a written confirmation of some kind of bid spec and a committed bid. Another type of form that you're going to use regularly is a California preliminary notice. I've got the private works version here. Let me just say this. In a private work setting, a general contractor needs to have a preliminary notice where there's a bank loan, a construction loan deed of trust on the project, and that should be disclosed expressly in the contract by the owner, and there should be a provision that says that if it isn't, then the owner is expressly warranting that there is no construction lender on the project, and giving them a deadline to tell you if that changes. General contractors otherwise are direct contractors, and typically do not need to do a preliminary notice. But then again, do you know who you're contracting with? Are they on title? You need to make sure that you're contracting with the property owner. Okay, if this turns out to be a disguised tenant improvement and you haven't run title, you may have just blown it. Okay, so you know, on big major contracts, you know, most contractors should have some title source. They should use some lien service company. We, you know, our sister, well, I would call that, but they're, you know, the owner of this law firm also has a separate business, Easy Law, that does mechanics lien services. There's others out there as well that provide lien services. They can do a lookup, and you can pay them to do a title lookup where you're concerned. Well, and you should always be concerned if you're a prime contractor that there is a construction loan on a project. Subcontractors need to do a preliminary notice always on private works. I don't care if it's a, you know, if it's $100 or $500. If you don't do the preliminary notice and they owe you money, you're last in line at the food bank. Okay, you know, folks with preliminary notices are going to be the ones that get paid first. Here's the 20-day notice on public works. If you need assistance in filling out any of these forms, you know, our attorneys and paralegals here, you know, regularly assist clients in making sure that they're filling them out correctly. Yeah, this is the affidavit, a proof of notice for public works, also important. So let's talk about conditional waivers and releases real quick. And unconditional. You should all be familiar, particularly in private works, with waiving your rights for liens. You should, if the money hasn't cleared your account, you should not be signing unconditionals. You provide conditionals until whatever the payment is made. And then once it's made, then you can provide the unconditional. But if it's progress, you need to make sure it's a through date. and is correct, and that there isn't money on change orders outstanding. You may have to add exceptions to your conditional waivers for other outstanding monies, or even exceptions to your unconditionals where there are other change orders in dispute or still in process. So, you know, don't thought every time you sign an unconditional waiver, you know, some thought needs to go into that, and people need to train their staff or be directly involved in that themselves, making sure the through dates and any exceptions are properly notated. And final means final. When, you know, you should not be out there doing any more work when you are doing on final payment waivers. If you're still doing punch list items or warranty work that you're not anticipating getting paid for, that's one thing. But if there's outstanding change orders in dispute, you know, where you know, or other things in dispute, you want to make sure that you're not signing finals. The AGC provides a notice of cessation. There are also notices of completion. These are things that owners and general contractors screw up regularly, pardon my French. It's really easy to do. As far as I'm concerned, you know, unless you have a lot of experience in doing them, you should have the benefit of counsel if you're going to be providing these notices. Recording a mechanics lien, you have 90 days from the date of actual completion of the work to record a mechanics lien. That is typically open for inference and debate when that is, but typically it's, you know, the factors are, is it final completion? Is it you know, did you get a sign off on a final inspection? Has the owner occupied and accepted the work? You know, has retention been paid? You know, those kinds of things. This is another thing that you do not typically usually record unless you're done working. If you still are planning on going back out there and working after you've recorded a mechanics lien, you need to think long and hard about that, and you need to consult with your lawyer how you're going to go about it, if at all. So, you know, Easy Law and other lien services provide these services. You should be dealing with people who deal with mechanics lien filing regularly, and you should not be doing these in-house, or I almost guarantee you will mess it up. This gets problematic too, where somebody in your office is serving an affidavit of notice. Why you want to use lien services is when some third party that's independent, you don't want to have to go in and explain why your employee is the person signing the affidavit. Critically important that any construction lender be provided a preliminary notice by a general contractor or a sub, because you also have potentially bonded stop payment remedy rights, which are critically important to getting paid, and particularly in big private works type projects. This is a stop payment notice. The stop payment notice is effective on the owner. It is not effective on a bank unless it's bonded. If you are in a payment dispute on a stop payment notice and you're going to deliver one, you should already be talking to a lawyer. I would say the same thing is true in public works context for stop payment notices, because even on payment and performance bonds and the other issues that you're dealing with there, they tend to be legally complex. Your lawyers should be drafting your releases of stop notices. They should also be review any discharge bonds, either for mechanics lien discharges or stop payment notice discharges. There are bonds that are available for both of those that either owners or general contractors can obtain. This is the DIR statement of compliance. You'll be familiar with this where you're dealing with payroll issues, typically in a public works contest or maybe a private works with a PLA, some kind of hybrid. Okay, this is one I have not reviewed, but this relates to that problem that we were discussing about equipment and whether you're renting the equipment or you're renting it with with operating personnel. I haven't looked at this particular form with the AGC. I'm familiar with the AIA form of this, or what I believe was the AIA form. Memory serves. Maybe it was AGC. I don't even remember now. But we have our own that we use at the firm. I prefer so. But if you're going to get involved with operating personnel and hiring operators for equipment, there's tremendous liability issues there. You need to take that. You be thoughtful in how you administer that and when you're contracting for that. So that's my phone number. I'm at extension 128, and my email address. Feel free to write it down, or if you're listening in, it's 805-306-1100 here at the office. And I'm Stephen, STEPHEN, at thegreenlawgroup.com. So I've got a few questions. Oh, somebody's asking me how long I expect this is going to take. I think we're just about done. I'm just going to handle a few questions here, probably another 4 minutes or so, give or take. Maybe 5 or 6. Binding versus non-binding arbitration. Okay, well, I don't consider non-binding procedures really an arbitration. I consider it more of a mediation or dispute resolution, non-binding dispute resolution procedure. Arbitration, as it's commonly understood, is a binding procedure that the parties agree on in lieu of court. So I would use either neutral dispute resolution or mediation as the terms for non-binding procedures, and then arbitration is binding, and it's either federal or it's maybe as promulgated by the AAA, American Arbitration Association, under certain rules. There's federal rules, there's private industry promulgated rules, or it's just as agreed on by the parties. I've had parties just come together and say, look, this is crazy. We need to get it into mediation, into arbitration, or we're never going to get our day in court. So we agree on rules. So, it should be in your contracts. All of the form of contracts have each of these non-binding dispute resolution and binding dispute resolution procedures. Now, I will tell you, I interpret binding dispute resolution procedures as arbitration or litigation, okay? However, I do add that now to the consensus docs to include arbitration or litigation so that the parties know clearly that litigation is binding dispute resolution, okay? And that came up in a case. So how do you go about selecting an arbitrator who understands construction, not only law? Very good question. Okay, so there are curriculum vitae resumes for all the arbitrators and JAMS, ADRS, ARC, AAA, and all the various different services out there. You review these CVs. You make sure that they put themselves out there. Then the other thing is, certain retired judges, certain lawyers have a reputation as being strong construction arbitrators, and others not so much. Okay, and so we know who we think are good and who we recommend to clients. But and then each of the arbitration administrative services provide their own rules and procedures for the appointment of arbitrators, and they're typically either a single individual or a panel. And my attitude about a panel is if the dispute is gross value dispute, it's less than $10 million,
yeah, one arbitrator, everybody agrees on it, let's move on. Okay, if it's over 10 million, then you want to be thinking about a panel. But even there are even situations where even much more expensive arbitrations, I would have a single arbitrator. Understanding you're giving up your right to appeal, except in very limited circumstances in a private arbitration. And it is expensive, but I would tell you in my experience over many years now of doing this, I would say, you know, litigation's typically double the price. You know, the one downside is whether I can get the discovery I need. And normally I can get the discovery I need from good quality arbitrators. They understand what's fair, and they will give the parties arbitrate, you know, the right to do certain, you know, discovery within reason. Those are the typical considerations. You know, how do I find them? Experience talking to other lawyers, talking to my clients. Okay, so I don't have any more questions. You know, I appreciate your time, and do feel free to reach out to me or any of the other very capable lawyers on our staff here if you've got any questions. I thank you very much.